We continue to read through this divorce case between Mr. and Mrs. Hall. Divorce after 4 months and 6 days. Summary of submission on behalf of the defendant, Mr. Hall. Counsel for the defendant submitted that the variation of the equal share rule is provided for under Section 7 of the Property Rights of Spouses Act, and argued that the defendant, Mr. Hall, met 2 of those considerations in this section. Those were that the subject property is wholly owned by Mr. Hall and was acquired by him 15 years prior to the marriage, and that the marriage was for a short duration. She also opined that Mr. Hall's lawyer also opined, she gave the opinion, that there had to be a clear, unequivocal intention to accept the child as part of the family, and that allowing the child to cohabit with them for 4 months and by providing general groceries do not mean that the defendant accepted the child as a child of the family. She submitted that Mrs. Hall had not produced any evidence to support her assertion that the child was so accepted, that means as a child of the family. Because if she was accepted as a child of the family, then Mr. Hall would have to pay child support. The defendant's position, that's Mr. Hall's position, was that he never assumed responsibility for the child's care or upbringing, and he never gave any input to the child's affairs. He accepted that he did assist with the extra lessons, but it was understood that the child's affairs were solely responsibility of her biological parents. Counsel contended that Mrs. Hall had received an order for maintenance from the child's father and therefore has the opinion to instigate the relevant process to recover any monies due and owing to her for maintenance of the child. The defendant also referred to Section 5 of the Maintenance Act and submitted that Mrs. Hall did not satisfy the requirements for her to prove need. That means a need for Mr. Hall to maintain her. It was also argued that Mr. Hall relied on her mother. Mrs. Hall relied on her mother for financial assistance, and though she mentioned that her mother was not working, she did not say how this affected the money that her mother sends monthly. It was submitted by counsel that if the court took into consideration all the funds from whatever source received by Mrs. Hall, a finding could be made that she is not in need of maintenance. That further, a person who is truly in need would find a way to reduce their expenses. She further submitted that Mrs. Hall received a judgment in her favor in the sum of $6 million. And from this, she had already received $500,000 and $600,000, between $500,000 and $600,000. That must have been from the accident. Counsel for Mr. Hall, the defendant, advanced the case of Antoinette Nancy West Laham versus Peter Laham, 2017, where the marriage lasted 1 year and 6 months, and the claimant had claimed that she was entitled to 50% share in the family home as she made improvements to the property prior to the marriage. Shelley Williams J., having reviewed Section 6 and 7 of the Property Rights of Spouses Act case law and the evidence before her, dismissed the wife's application in its entirety. It was submitted by counsel that the same ought to be done in the instant case, as the marriage was considerably shorter, and the claimant, Mrs. Hall, has not asserted a common intention or provided evidence of any improvements to the house. She said that the judge had also denied the mother any maintenance for the child, though the evidence was that the husband took the child to school and gave her lunch money from time to time, among other things. The learned judge had concluded that the child was not accepted as child of the family, and that the child was not in need of maintenance. That's in that particular case. Therefore, counsel posited in the instant case that the claimant, Mrs. Hall, had already been awarded an order for maintenance for the child and was not entitled to maintenance for herself nor the child, and she had also not shown that the defendant is in a position to assist her financially.